Hello, I'm Barry Kantrowitz, one of the partners at Kantrowitz, Goldhammer, and Grafman, a 12-lawyer firm located in Rockland County, New York, and Bergen County, New Jersey. Our firm practices throughout the New York metropolitan area. Today, several of our family law attorneys will speak to you concerning your rights and obligations in matrimonial and divorce actions. During this 20-minute presentation, they will discuss the following topics: the difference between divorce and separation, grounds for divorce, violence in the marital home, alimony and spousal maintenance, child support, the duration of alimony and child support, and equitable distribution, including the evaluation of pensions and business properties. It is important to note that the advice in this program is general in nature. You should not rely solely on this presentation for your legal advice. An attorney from our firm will meet with you shortly to discuss your specific case. All of the information in this presentation may not apply to you, and your circumstances will likely require specific legal advice.
Hello, I'm Paul Goldhammer, and today we're going to speak about matrimonial law. There are 5 major issues that we have to discuss. The first of which is grounds for divorce, whether or not you're entitled to obtain a divorce in the state in which you're located. The second of which is custody and visitation, which is almost self-explanatory. Then we have to talk about equitable distribution. Equitable distribution is the ability of the judge to divide the property between the parties as they see fit and pursuant to certain rules. Then we have to talk about alimony and/or spousal support, and of course, child support.
What are grounds for divorce?
The grounds for divorce are the reasons why a divorce is requested. The grounds for divorce in New York and New Jersey are very similar. They are adultery, bad conduct within the marriage, in New York being separated or abandoned for 12 months or more pursuant to a written agreement, in New Jersey being separated without an agreement for 18 months or more, and being institutionalized in a mental or penal institution for a measured period of time. Currently, the most common cause of action for divorce in New York is irretrievable breakdown, and in New Jersey is irreconcilable differences. Despite the difference in name, both stand for the same concept, that there has been a breakdown in the relationship between the parties for a period of at least 6 months. Now, thanks to irretrievable breakdown and irreconcilable differences, a unilateral claim that there's been a breakdown in the relationship is enough to have a divorce granted. Your specific circumstance may require a more in-depth discussion of other grounds for divorce. However, outside very specific circumstances, the choice of grounds will not generally affect your equitable distribution or support, and almost always a divorce will be assured.
What is equitable distribution?
Equitable distribution is a system of law by which the judge is authorized and empowered to divide the property that has been accumulated during the marriage. The judge has the power to divide the property that's been accumulated during the marriage equitably. That does not necessarily mean 50-50. It is more likely than not, the longer that you have been married, that the division will be 50-50. But property that the judge cannot distribute is property that was acquired prior to the marriage, property that was received as a result of a gift, property that was received as a result of an inheritance. But all other property is subject to distribution. This includes the growth of property if it existed prior to the marriage, if it grew as a result of the fact that you worked on it during the marriage. Under the laws of equitable distribution, all types of property can be divided. That means real estate, money in the bank, stocks, bonds, the value of businesses, pensions, profit sharing, IRA, any type of property that's been accumulated during the marriage. It is not relevant that the property is owned by the husband or the wife, or both of you. It is subject to distribution.
How do I know what my pension is worth?
Some pensions are easily identifiable as to their worth. That's particularly true in a 401k, a profit-sharing plan, or an IRA. This is not true in a defined benefit plan. If an IRA has $100,000 in it, it is easy to divide it in half. but a defined benefit plan pays a certain amount per month at a time in the future. In order to evaluate that, we have to hire a pension actuary who will give us a present cash value. There are several ways that pensions can be divided. They can be divided on the spot and broken up into two different pensions, and usually done without tax ramifications. That is done by use of a QDRO, a quadro. That stands for a Qualified Domestic Relations Order. That enables us to break up a pension into two pieces, one for the husband and one for the wife, and they will then be able to both handle their pension as they see fit in the future. If we trade a value, we have to have a present cash value of what the pension is worth today. Sometimes people want to trade cash for the pension in the future, or trade for a piece of the house. All of these things can be accomplished.
What about our business?
Another property subject to equitable distribution is businesses. If you own a business, it is marital property if it was founded during the marriage. If it was not founded during the marriage but grew during the marriage, the growth of the business is subject to equitable distribution. In order to establish the value of a business, we will hire a forensic accountant. It is his job to determine the true value of the business for equitable distribution purposes. In addition, he will also help us calculate what the true income is of the business owner. As a general rule, equitable distribution is equitable, not necessarily equal. There are 13 factors used to establish what the equitable distribution should be. They are the duration of the marriage, the age of the parties, the needs of the parties, the past earning abilities of the parties, the future earning abilities of the parties, and the current amount of assets. Equitable distribution can be 50-50, or it can be 60-40 or 70-30 or any other combination of percentages. The longer you are married, the more likely the distribution will be 50-50. Other types of property have to be evaluated as well. This is true of the summer house, the house in which you live, or any other assets that are owned by the marriage, including the automobiles, jewelry, or any other asset that you might have. It is extremely important to be accurate in the evaluation of these assets. If you trade off an asset which your spouse has valued at a greater value than it is worth, and you keep it, then that will change the amount of money that you have received. Likewise, if they are keeping an asset, such as a business, and the evaluation has been artificially low, it will appear as if they got less than they are entitled, and therefore will want more from your half.
How is custody of a child resolved?
Before we can reach any determination as to alimony or child support, we have to have a resolution of custody and visitation. In New York, joint custody does not exist unless it exists as a result of an agreement. It is a rare case where a court will order joint custody in the state of New York where the parties have not agreed to it in advance. In New Jersey, they grant joint custody in almost every case, even if it's not really joint custody. Joint custody in New York or New Jersey can be defined in any way you would like under your agreement. I have seen joint custody agreements where fathers see their child only every other weekend. Then again, there are joint custody arrangements where people share their children almost equally. If the parties fail to make an agreement in their separation agreement as to custody, then the judge must make a determination as to who will receive custody and what visitation will be awarded. In order to reach a decision on custody, the parties will be seen by a forensic psychiatrist. The forensic psychiatrist will interview the parties, the children, and any other significant people involved in the matrimonial action. That will include sometimes grandparents, brothers, sisters, stepbrothers, and sometimes boyfriends or girlfriends. When the court makes a determination as to custody, they must be concerned with what is known as the best interests of the child. Best interests of the child can be defined as what will be best for the child going forward. In order to make that decision, every judge will look at who has been the principal caregiver of the children up to and including this time, and who, without reference to finances, has the best ability to continue to provide a nurturing atmosphere for the children.
How will visitation work?
Visitation does not have to be every other weekend and nothing else. We normally divide vacations, the summer, alternate weekends, and sometimes more, and sometimes we have visitation during the week. Occasionally we have visitation sleepovers during the week, depending on the age of the children. A custody or visitation determination has to be made with reference to what children want as well. However, the truth is that if the children are under the age of 8, judges, though they may interview them, will give little credence to what the children say. If children are between the ages of 8 and 12, they will pay some attention to what children say and give it some weight, but will not give it great weight. They will rely on the psychiatrist, the testimony that they hear, and the determination they make will be made with their best common sense. However, if children are over the age of 12 and are vocal, judges will listen to them specifically. The children will have either a law guardian or a court-appointed attorney known as the children's attorney to represent their rights. In family court, we sometimes get this for free. In Supreme Court, the parties will have to pay the law guardian or the court-appointed attorney for the children. This court-appointed attorney for the children will advocate what they believe are the children's desires. They will advocate them notwithstanding that it may not be the best thing for the children. They represent the children and will take the children's position. In 98% of the cases, the parties work out custody and visitation without the help of a judge. It only comes down to a judge's decision if the parties are absolutely unable to resolve this together with their lawyers.
What is alimony?
Alimony, or what's commonly known as spousal maintenance, is a payment that one spouse makes to the other over a predetermined amount of time, either ordered by a court or agreed upon by the parties. This is usually thought of as a permanent payment after a divorce has already been finalized. However, in both New York and New Jersey, the temporary maintenance or alimony can be paid. That too can be ordered by the court or agreed upon by the parties. It's commonly referred to as pendente light support. And the reason for it is to maintain the financial status quo that the parties enjoyed during the marriage and prevent an unfair or unjust financial shift between the parties while a divorce is pending. With regard to temporary support or alimony, New York and New Jersey differ in this area. New York has structured guidelines that take into account a cap of income and other factors to be determined in arriving at the amount to be paid, while in New Jersey, the practices are more discretionary. If you want to learn more about either one of these practices, speak to your KGG attorney. With respect to final alimony or support, there are several questions to consider. The two most important questions are how much support will be paid and for how long will it be paid. Both in New York and New Jersey, courts can consider a series of factors when applying either the amount to be paid or the term under which it must be paid. In New York, with respect to the payment of support, there are caps on the portion of one's income that the support is paid upon. This number changes every year and generally increases. The rules provide a list of factors that a court can take into consideration when determining an amount and duration of support. This includes the health and age of the parties, their respective histories in the workforce, the standard of living the parties enjoyed during the marriage, and how much equitable distribution a party receives regarding their assets and things of that nature. Under the rules in New York and New Jersey, the paying spouse sometimes gets a full or partial credit for the monies they pay in spousal support, which effectively lowers their child support obligation, assuming there were children in the marriage. Critically, as of December 31st, 2018, spousal support or alimony is no longer federally tax deductible for the payor or tax declarable to the recipient. New York and New Jersey tax rules on deductibility are different than the federal rule.
How is the amount of alimony determined?
The amount of alimony that is paid has to do with the age of the parties, the duration of the marriage, and the amount of money that the people earn. Alimony can be for a very short period of time, no period of time, or for a measured period of time. It can also be for a lifetime. The amount and duration of alimony is determined based on the specific facts of your case, and factors that are counted, again, are the duration of the marriage, the education of the parties, the age of the children, the amount of assets accumulated during the marriage and how they have been divided, as well as the people's expected ability to earn money in the future.
How is child support assessed?
If there are children involved that are unemancipated, we have to discuss child support. Child support is money paid by the non-custodial parent to the custodial parent to help support the children. This money is not paid directly to the children, but is paid to the custodial parent so that they can pay the mortgage, the taxes, the utilities, and the expenses that come along with raising children. A payor is not entitled to an accounting of how and in what way the custodial parent spends the money. In New York or New Jersey, or in fact in every jurisdiction in the United States, each state has a Child Support Guidelines Act of some sort. In New York, we call it the Child Support Standards Act, but it is also referred to as the Child Support Guidelines Act. In New Jersey, it is called the Child Support Guidelines Act as well. In New York, the actual formula is complicated, but for ease of thinking, you can assume that the non-custodial parent will pay 17% for one child, 25% for two children, 29% for three children, 31% for four children, or 35% for five children. If you have more than 5 children, make it a point to tell us.
Is child support tax deductible?
Child support is not tax deductible and is not tax declarable. It is the equivalent of opening your wallet after you've cashed your paycheck and handing dollars over to your ex-spouse to help them support the children. In New Jersey, they use a chart or a software program to calculate support. The maximum weekly income measured by the program is $3,500 per week. At $3,500 per week, the child support is about $325 per week for one child. If the income goes over $3,500 per week, it is the judge's obligation to work out what should be paid. In New York, you will hear that child support is capped at
currently $148,000 per year, which may be increased from time to time.
That is not true in Rockland, Westchester counties, or New York County. In fact, it is not true in downstate New York in general. However, they will not grant child support on your entire income if you earn $1 million per year. There are cutoff lines and they change from county to county. You may be wondering who has the right to deduct the children. That is actually governed by the IRS code rather than by New York state law. The person who has custody of the children has the right to claim the children as tax deductions.
How is the value of assets obtained during marriage calculated?
As I told you previously, the marital assets have to be divided. But there are some assets that get divided based on values at different times. The value of the house will be the value at the time it's sold. The value of the pension and profit sharing will be the value at the time the divorce starts, together with any accretions or depletions that have occurred as a result of the economic market. The value of the business will be the value as of the date the divorce starts.
Do I have to stay in the home during proceedings?
When it comes to staying in the house voluntarily, as a general rule, I tell my clients to stay in the house pending the divorce. If there is violence, you must specifically bring this to our attention. However, if you leave the house, you will be giving up control and some rights to the most important and valuable asset in the marriage. Further, if you are the person who leaves the house, and if you leave your children behind, custody will be resolved by that statement. If you leave the marital home, and you have to set up a house elsewhere, you will probably be ordered to continue to support the marital abode at the level at which you were supporting it prior to the separation. If that happens, you will most often find yourself to be financially stressed. If you are thinking about moving out of the marital house, make sure you discuss that with us specifically, because as a general rule, it makes it very difficult to settle the case if you do that.
How long does a divorce take?
If the parties can reach an agreement as to how they're going to divide their assets and as to custody, visitation, and child support and alimony, from the day you sign that agreement, you can be divorced in 8 to 12 weeks. However, if you can't make an agreement, then the judge has to make the agreement for you. And when the judge makes the agreement for you, you have to go through different procedures. In Bergen County or Rockland County or Westchester County, a divorce will take no less than 9 months if you can't make an agreement, and probably as much as 1.25 years. In some of the other jurisdictions, like Bronx, Manhattan, Brooklyn, it can take well longer than 1 year.
How is the house divided?
At the end of the action, the judge can make a determination, or you can make this determination in your agreement, as to who will stay in the house or who will even keep the house. Assets can be divided in kind or can be divided up so that each person gets a percentage of each asset. It is not uncommon that a custodial spouse who is taking care of the children will remain in the house and have exclusive possession of the house for a measured period of time. That can be for several years or until the youngest child is 18 or 21, or any time that the parties agree to or the judge selects. Exclusive possession of the house does not necessarily mean ownership. A judge or parties can agree that a person can stay in the house for some measured period of time without affecting ownership and have the proceeds of the house divided at a later time.
What is the difference between a divorce and a separation agreement?
A divorce judgment is a document that legally severs the bonds of matrimony between the two of you. It makes you separate and apart and single. A separation agreement is nothing more and nothing less than one of the largest financial contracts that you'll ever sign in your life. It resolves and sets forth the financial issues, the custodial issues, the property issues, and any other issues that you may have. The agreement can subsequently be adopted, if prepared properly, into the judgment of divorce. If you make an agreement, you resolve all of the terms of your divorce, and then the judge incorporates it and makes it a judgment of the court. If you can't make the agreement, the court makes the agreement for you, and in that event they call it a decision, an order, or a judgment. And in that case, the judge makes the determination for you. When the judge has to make the determination, it is more expensive and takes a lot longer.
Should I consider a separation agreement as opposed to a divorce?
When we say you should have a separation agreement, we are not suggesting that you should not become divorced. A separation agreement is a methodology of reaching the divorce without having a trial. By having a separation agreement, you know all of the terms when you sign on the dotted line. When you have a divorce judgment without an agreement, you don't know what the decision is going to be until the judge makes it. A separation agreement avoids the trial. It avoids certain steps that you have to take to become divorced. As a result, it saves you time, it saves you money, but most importantly, you know exactly what you agreed to when you sign on the dotted line. We have just spent a few moments talking about matrimonial law in New York or New Jersey. It would be unwise to rely solely on this film for all of your information concerning your personal problem. You are about to meet with a matrimonial lawyer from this firm who will address any specific problems that you have. In the interim, if you would like to back this disc up and view any portion of it again, feel free to do so. When you are done, please go out and tell the receptionist that you're ready to meet with our lawyer. In the meantime, I'd like to wish you good luck.